Hello, I'm David Allison. I'm a director at Family Law in Partnership.
So my name's Elizabeth Hicks and I'm a family lawyer and director at Family Law in Partnership.
Going to court can be the best option for some individuals, usually if they need a decision made. So if there's a particular issue of law or fact that needs to be decided, then that needs to be resolved before they can move forward. And sometimes it's necessary to start proceedings simply to get a timetable in place if matters can't be resolved otherwise.
There isn't really a particular type of family case that tends to go to court. It really does depend on the particular facts of the case. Quite often, if there's an international dimension to the case, you have to go to court in order to secure the jurisdiction of the court in England and Wales. And also quite often it depends on the personalities that are involved.
As Elizabeth has said, it really depends on the facts of the case whether it's necessary to go to court. But where the stakes are high are where cases often go to court. So where there are jurisdiction issues and the outcomes can be very different in those different jurisdictions, a decision can be needed. International relocation of children is another one because people see it as a very binary outcome and therefore they need a decision.
FLiP's overall approach to litigation is wherever possible we try not to litigate for our clients. Our preference is always to try and reach an agreement either through mediation, through arbitration, through sitting around a table and trying to negotiate an agreement with the other side. However, there are sometimes cases where you have to go to court to get a decision. And in those cases, FLiP's approach is that we won't descend into the nastiness of litigation. We don't send letters for the sake of it. What we'll always do is try and have a constructive dialogue with a lawyer on the other side and try and reach an agreement, if at all possible, as soon as we possibly can.
As Elizabeth has said, what we don't do when we litigate is to get into nasty, aggressive correspondence. And that's not because we think that's the best way to do it, it's because it is. Because judges don't like aggressive, nasty correspondence. And even if you're looking at it purely tactically, it's sensible to be pleasant, assertive, but pleasant in correspondence. That's what judges expect to see, and that's what gets the best results.
Sometimes people go to court because frankly, their relationship between each other is so toxic that they actually need a third party to make a decision that's imposed on them. I've frequently had clients where they just feel that because of the situation resulting in the breakdown of the relationship, they don't trust the other party, and therefore they feel that they really want a judge to make a decision because it's the only way, for their perspective, that they can get closure.